JP, thank you again for talking to us from Encoded Law. Now, some people view, rightly or wrongly, the Pretoria High Court as, some people have said, a place where the dreams of black litigants go to die. And they use the example, for example, of the Makate versus Vodacom case, where he was shot down there and then he was vindicated in the Constitutional Court ultimately. And also a judgment that involves the former president. Now, I don't want us to get into details of the facts in that case, because you said in that judgment, I'm talking about the state of capture case, where the former president sought to set aside a remedial action by the former public protector. What I want to focus on specifically is that the president, in terms of the Constitution, is the only figure that has the power to appoint not only the commission, to set up a commission of inquiry, but also to appoint the chairperson. Now, in the state of capture case, the debate was whether a president who is implicated in that very investigation or pending investigation by the commission of inquiry should be allowed to exercise his constitutional power of appointing a chairperson of a commission of inquiry. Now, I don't know the background and what happened behind the scenes, but would you say, without reviewing your own judgment, that it is a place of a court to, I hesitate to say usurp, but to prevent a constitutional being in the form and shape of a president from exercising his power purely on the basis that the investigation by the Commission of Inquiry is about him?
Well, I think, let me start with the first question you posed about the Pretoria court killing black litigant dreams. I've not had it expressed that strongly, that view, that is. And I would be frankly surprised. That court deals with more work than the Johannesburg court. People find that difficult to believe. And I, as JP, who allocates work to judges, see a lot of black litigation that is successful in that court. So I think I just wanted to deal with that, to say, look, Makate is one case, right? A swallow doesn't make a summer, as they say. But unfortunately, in our space, you can do a lot of 1,000 good things. 1,001 could be the wrong one, and it diminishes everything else. That's our context. But I want to dispute the fact that that court is against black litigants.
Doesn't it worry you that that seems to be the perception? It may not be true.
I'm not saying it's true or not. I'm saying I've not heard it being expressed that way. And I listen a lot to the radio stations, you know, that report on the court, on the work that we do in the courts. I look at headlines. I mean, News 24 is on my phone. I check what's trending, so to speak, you know. So I've not heard that view being expressed. If it's there, I would like to deal with it, you know, in my engagements, because I opened that space for me to deal with civil society, right? To say, look, are there issues that people want to raise about the courts? It's never been raised with me.
You should get a Twitter account, JP. That's where the pulse is.
That's where the pulse is, yeah. But people are irresponsible on Twitter. They tweet anything. You know that. My kids are on Twitter. My kids are on Twitter, and they tell me. And they say it's good for me I'm not on Twitter, because some very bad things have been said about me on Twitter or on Facebook.
Well, the former Deputy Chief Justice was on Twitter. I'm not sure if he still is. But okay.
Let's come
Now,
to the state capture case about our decision.
No. Well, I don't want us to phrase it like that. We're not coming to the state capture case on your decision because we're not reviewing your decision.
Okay.
I'm asking a general question about whether it is for a court to take away a power, a constitutional power of a president to perform, in this case, to appoint a judge to sit as a commissioner in a commission of inquiry, simply because the president himself is the subject of that investigation.
Yes, is alleged to be tainted or whatever, or conflicted.
Absolutely.
You see, that was the first one. The other case was the Sean Abrams case. I'm sure you remember it.
Yes.
Where I presided on that bench, where we said, Mr. President, because you conflicted, and as far as the NPA is concerned, you can't exercise the power to appoint another NPA head. The deputy president must do that. It's the same principle, isn't it?
Well, not quite.
Well, you want to debate it with me, fine. But let me finish what I want to say.
Yes, but we have to get the Sean Abrams thing out. You know, there is a presumption of judicial impartiality.
Yes.
There's no presumption of an NDPP impartiality.
Yeah.
So I'm not sure if the two cases are comparable. Because my follow-up question is about the independence and impartiality of the judge. So, but carry on.
Well, I thought your question was, can a court take away a constitutional power?
Yes.
Because that's how you phrase the question.
Yes.
So I'm bringing the Sean Abrams case on that basis.
Okay.
Right. To say the court did the same thing.
Okay.
To say, Mr. President, you are therefore, because you are conflicted, you are unable or not available. Your deputy will exercise that power. Okay. That was our reasoning, right? Now, coming to state capture, you correct perhaps that you can't compare the two cases, but the issue there was a public protector had wrapped her head around the issues and had said, this investigation is big. It calls for a commission of inquiry by a judge. Now, I'm aware, that's public protector, that the president must, but the president features prominently in what is alleged to have gone wrong. Here, what message are we sending out there if the same president appoints the judge?
Can I ask you a follow-up? Can I answer that with a follow-up question?
Okay. Because I haven't finished answering your question.
Okay, continue. Yeah. Please proceed.
So she then wrapped herself around that issue and said her remedial action is that the president must appoint a commission, but he shouldn't be allowed to choose the judge. And that's your question. The Chief Justice should be requested to choose the judge, and that's the person the president must appoint to lead the Constitution.
Yes.
Right. Now, it's remedial action. I think the Constitutional Court itself has told us in the judiciary how to treat remedial action.
Yes.
And we treated it in that same way.
Yes.
You know? Hence we said it's proper that this power be exercised this way because of the location of this matter in the South African society psyche, to say this is what's happening in this country. Therefore, the Chief Justice will appoint the judge.
Okay. Now, Judge President, in the president who is alleged to be implicated in the investigation.
Alleged, I'm happy you said that.
Yes, alleged to be implicated in the forthcoming investigation because it was forthcoming at the time.
At the time.
By the Commission of Inquiry. What bearing would the president's appointment of the judge on the impartiality and independence of the judge himself in performing that function?
I think the issue is not what bearing, but is the rot identified, or alleged rot, let me use the word alleged, identified by the public protector, cried out for a clean investigation that invited no criticism at coming to whatever recommendations are there. And we approached it on that basis to say that we actually agree, right? We're not saying any judge who may be appointed by the president will dance to the president's music. We're not saying that, right? We actually saying it will benefit the process if action recommended by the public protector is adhered to as it was.
But isn't that the implication? I mean, if you're going to say the president who is allegedly implicated in the investigation by the Commission of Inquiry cannot appoint the judge who's going to chair it, isn't that an indictment on the independence of the judge? Because the judge has no say in whether he gets appointed or she gets appointed or not. Isn't the issue about the independence and impartiality of the judge in carrying out his or her functions, having been appointed by the president? Why should the fact that the person who appoints the judge, who has a presumption of impartiality and has sworn an oath in terms of the Constitution, why should the president being implicated affect the impartiality of the judge?
Yeah, I think what you're touching on is the aftermath of our decision. There were these opinion pieces that were penned about whether we've gone too far as a judiciary. And what you're suggesting is that we went too far in the sense that we actually made an indictment against anyone appointed by the president.
No. What I'm
by
saying,
the president.
What I'm saying is the implications that it may have. I'm not saying you. I'm not.
No,
I
but that's the effect.
That strongly.
That's the effect. That's the effect of your question to me. To say we were actually saying, if the remedial action recommended is not carried out as is, but that the president is allowed, it means when we refused that, we were saying no judge will do it properly if appointed by the president. That's what you say. We didn't go that far. We just looked at the process as is, you know. And I think we may have tried to clarify it in our judgment. Maybe we didn't. That we're making no implications or imputations against anyone. But in our view, the process will benefit better if this remedial action is carried out as is.
Okay, well, let's leave it there, Judge President, because that to me sounds like, you know, when someone is about to disrespect you and says, with respect, and then continue to make the point. But
I didn't say that.
No, when you say
and it's counsel, and it's counsel who like saying with respect when they want to disrespect judges.
And I never use that term for a very good reason. Now,
thank you for, Mr. Ngalwana, you're correct. You know, we do not take these decisions lightly.
I have no doubt.
Right. And you have asked me these questions and you've tested my reasoning. I have not gone back to read the judgment, but I remain fortified that we were persuaded that as judges, justice demanded that we uphold the remedial action as it was for the sake of this country, you know.
Okay. I want to ask you the question I was going to ask you, perhaps on a different occasion. Now, I've got two last questions. The one relates to briefing patterns.
Yes.
Now, I know you've been a strong proponent for improved briefing patterns and you started a process, I think, of council or registrars filling out forms so that you can keep track
Yes.
of what's going on there. Now, would you say briefing patterns have improved since you started or you embarked on that process in the High Court?
No, I've seen no. The improvement may be there, but very slight. But it continues.
To what would you attribute this reluctance to brief black people and women in general?
I don't know. I've tried my best to try and come to the bottom of it and understand it. It's a mystery, and it relates mostly to the commercial work, you know. I mean, when you go in the unopposed motion court, the bank's work, that work still goes to white male counsel. You can sit in any unopposed motion court, you'll see. White males predominate in getting that work. And when you look at the firms that are getting that work from the banks, some of whom are led by blacks, by the way, right? These are so-called white firms. So I know white firms have established links with white counsel, you know. Probably that's what it is, I don't know, you know. But it's a problem that I continue to identify. And you go to the RAF work, you know, that's regarded as black work, you know. You go to roll call, you see a sea of blacks, black males in particular. So something is driving these briefing patterns.
What is it that you think black counsel, the senior ones, can do to help change that pattern in the whatever small way they can?
Look, I used to subscribe to the notion that maybe they could be invasive. I know the Johannesburg Society of Advocates introduced rules that when you have juniors, I don't know, one of them has to be black and stuff like that. I don't know to what extent, because that addresses the big work, like the opposed motion work or the special motion work. But the unopposed motion work, that's basically nothing, but that's where the bulk of the white work is. You see? So I don't know to what extent, because you don't need a silk in the unopposed motion court. You know, so I don't know. I think the bar itself needs to interrogate this trend further, and my statistics are here. I can share them with you. You know.
Well, we can only hope that the new bar, Pabasa, will at least do something about this.
Yeah.
One last question, Judge President. Judges expressing personal views and political views publicly. Let me ask a broad question. Does becoming a judge mean that the person who's now been elevated to the bench loses his or her Section 19 rights, political rights, and freedom of expression rights? I know there are limitations to these, but I have found that judges are very reluctant to express personal opinion on current affairs matters publicly. Is that what we should understand to be a requirement if one wants to be a judge? That suddenly now you have no views publicly?
Well, you lose, as far as I'm concerned, you lose that right to air your views publicly. You still have your views. You lose nothing, but you lose that thing of standing in a public platform and expressing yourself on current issues, because these issues, and as we've seen in the last 3, 4, 5 years, these things land up in the courts. Right? So if you've expressed yourself already, taken a position out there, that takes you out of hearing any of that matter. Whereas for me as judge president, I allocate the work. If I express myself that way, so whoever I allocate to do the work will be tainted by what I have said. So we think it's better for the process and for the judiciary to stay out of the public space on these current affairs issues. I think it serves the country better that they hear our views when we write our judgments.
Now,
or they get to know what our views are when they read our judgments.
There is a judgment of the Canadian Supreme Court, and for the life of me, I haven't been able to find it, but I read such a judgment a couple of years ago, where a justice of the Supreme Court, it's a woman, said something and was hauled over the coals by an equivalent of the JSC, and eventually was vindicated. The Supreme Court in Canada found that the justice has a right to express her views. She cannot be muzzled. She doesn't lose her political views simply by being elevated to the bench. I'll try and find that judgment again. Now, would a judgment like that not change your mind?
I would like to read
your outlook.
I would read it, but South African society as is currently is very polarized. You know, people watch who says what, where, in what context, and they use it against you. I mean, if you look at JSC interviews per se, a lot of the things that the candidates have said or have done is brought back to them, sometimes to bite them, or sometimes to bring about their downfall. So I think it's better for the judiciary to stay out of the public space. I think it's better. You know.
Well, Judge President, thank you very much for your time. And yes, we hope to have a more in-depth discussion, perhaps when you decide to do your autobiography or you commission someone to do your biography, so we can drill deeper into those two rivulets of your
of
background.
My background, yeah.
Thank you very much, Judge President.
Thank you. Thank you.